Outside. Outside.
Who else is in the house, ma'am?
My 2 children and my husband.
Where's your husband at?
Calm down. Calm down.
You want the children down?
Call them all down.
Mr. Jones, come down the stairs. Now!
Police, come down now.
Search warrant.
Bring
Come
your
down the
children.
stairs.
My children!
Hang on, let me clear the
He
house.
just pointed a gun at my children!
Search warrant.
And welcome to Law&Crime Report, everybody. I'm Jesse Weber, and thanks for joining us. That's where we're going to start. We're going to start with the raid on, and what you just saw, the raid on Rebecca Jones' house. And again, of course, she's the Florida data analyst who was fired after she says she refused to falsify the state's coronavirus numbers. Well, she turned herself in to authorities after a warrant for her arrest was issued, and she's now facing one charge of offenses against users of computers, computer systems, computer networks, and electronic devices. She's accused of illegally operating the government's messaging system to send out statements regarding the state's COVID deaths. And she's currently out on bail, but in a strange twist, as if this story couldn't get any stranger, she told reporters that she tested positive for coronavirus. Okay, so there's a lot to break down. I'm joined by criminal defense attorneys Gabriela, Teresa, Gonzalez, and Gilbert, Parris. I'm happy to have you both here to break down these stories. Gigi, I'm going to start with you. I know this is a story you've been following in Florida. And what exactly, let's start here, what exactly is the charge that she's facing, and does it carry significant prison time?
Sure. So she's facing offenses against computers, and that's Florida Statute 815.06. She's being accused of what is a third-degree felony. So there is possible prison time, but depending on how the case is resolved, she may be able to avert that, especially if she doesn't have any criminal history, and especially if she's able to successfully assert that the state is violating her First Amendment rights and that she was not the hacker in this case and that she did not send these messages.
And that's where we're going to get into her defense. And you might be asking, why did she turn herself in? Well, she released a statement that says, to protect my family from continued police violence and to show that I'm ready to fight whatever they throw at me, I'm turning myself into police in Florida Sunday night. Okay. And, you know, this isn't the first time that we've heard this story. We've actually covered it on the report. But Chris Cuomo over at CNN had an opportunity to delve into this matter a little bit more. Let's hear how we'll get a further glimpse into the mind of Rebecca Jones.
They took my phone and they took the computer that I use to run my companies. And on my phone is every communication I've ever had with someone who works at the state, who has come to me in confidence and told me things that could get them fired or in trouble like this. And I just want to say to all those people right now, if he doesn't know already, DeSantis will know soon enough that you've been talking to me. So be careful.
Okay, now this is a tricky case, Gilbert, because you have somebody who's not only going to defend himself, but she's also filed a lawsuit. And I'm curious, we'll get into the lawsuit in a second, but if we talk about her overall defense, that she did nothing wrong, that she's the good guy here, what is her defense? Because the way I understand it, although they tracked the IP address to maybe her residence, that, you know, to say where the messaging system was hacked or used, that might not be so accurate. So let's talk about what her defenses are to this criminal charge.
Yes, well, first, good morning, Jesse and Gigi. Great to see you both. Well, first, she's asserting that all of her communication was legal to start out with. So her defense appears to be whatever it is that you're going to find on my phone will have nothing to do with a violation of the law. The question of whether or not the warrant is going to be overbroad, she just mentioned that since every single conversation she had is on that phone, and it might address matters that have nothing to do with what's under investigation, might be able to limit the government from utilizing certain questionable communications, whether or not they point to her case or not.
Yeah, and again, she had filed a lawsuit alleging that the FDLE violated her constitutional rights. But Gigi, the idea that just because they tracked this IP address doesn't necessarily mean she did what they're accusing her of doing. And if it ultimately turns out that she really didn't hack the messaging system, although I will tell you what they allege she said through this messaging system is pretty, important, where she said it's time to, or she allegedly said it's time to speak up before another 17,000 people are dead. This is wrong. You don't have to be part of this. Be a hero. Speak out before it's too late. Seemingly speaking to the state officials. It almost seems like, based upon everything we know of Jones, this looks like something she would have said, right? I mean, she files this whistleblower complaint. She's talking about how the state is trying to cover up how bad the pandemic is in Florida. And now they're saying she hacked this system to ultimately get the message out. So there's a way she can defend this, but at the same time, it kind of looks like she's the one who did this.
It's definitely convenient for sure, but let's keep in mind what the timeline looks like. We've got her at odds with DeSantis, saying that she's refusing to falsify COVID numbers, refusing to downplay the severity of this pandemic, which has hit Florida exponentially hard. She gets fired. Then she files a whistleblower complaint. Then, following the election, she conveniently sends a message out saying, fight the system, be a hero, don't let them falsify, which now opens the door for the FDLE to go and investigate her for potentially hacking the system. It seems really convenient. And her attorneys are doing a really good job at bringing forward the defense and the point that these IP addresses are easily spoofed. And not only that, that the network that was accessed was openly available to the public. So this really could have been anyone. And it's really looking like the state might be just using this as a convenient opportunity to get wind of who's feeding her information so that she can not publicize further information that she's getting from her sources in the inside.
Gigi, you raise an interesting point. Gilbert, there was some discussion about this as well. When they raided her place, they got all this electronic communication. And it's not only what they can build a case against her, but also against who fed her information. There were some claims that the state workers, these whistleblowers who, she got this information from, they might be in legal jeopardy. So how does that work exactly? Because you have to assume the government now is in possession of a lot of this material. And are they tracking down who, maybe worked with her, who gave her information, where she got this data from? Are they in legal jeopardy, and what kind of legal jeopardy?
Well, as you know, Jesse, the whistleblower cases, and we had a huge one under President Obama's administration, where people who are in possession of confidential information, if that is revealed, and of course, if it's going to present a danger to the public, which is why it's classified to start out with, they could find themselves in legal trouble. But this seems to be somewhat of a minefield when you're dealing with information that might have, where the public should have known about this to begin with. It should have been disseminated to start out with. I know that her lawyers will probably take, and any of the other people who might be considered whistleblowers might take the position that, number one, some of this information was not supposed to be classified, whether it was considered classified at the time. And number two, whether or not it was properly gained, as Gigi has just mentioned, in terms of being accurately traced over to this communication, or is this merely a ruse in order to get as much information as possible through either legal or means on the fringe of legal warrants to be able to track these people down?
It's an interesting case. I'm curious to see how it plays out, because if she was trying to do the right thing and saying the state was up to no good, and now she's being charged with this crime, do you still prosecute? Is it difficult to convict? How is this going to play out? There's a lot of moving factors. We will continue to update you in the Rebecca Jones case, but I want to switch gears because there's another ongoing legal issues, I should say, that are still stemming from the Capitol riots. Because there is now a report that one of the rioters at the Capitol may have stolen a laptop from Nancy Pelosi's office. Can't make this stuff up, everybody. So the FBI is looking into whether Riley June Williams took this device and planned to sell it to a contact in Russia, who then was going to send it or sell it to the SVR, Russia's intelligence agency. Now, the sale never happened. This never occurred, but Williams hasn't been charged with anything in regard to the laptop. She was arrested for violent entry or disorderly conduct. Those are the same charges that many of the rioters follow. But this is a very interesting case. And Gigi, let me start with you on this. I'm curious. Now the FBI is looking into it. It came from a tipster, But does it seem like a strong lead? Does it seem like a strong case, or is this just one of those more outlandish tales that are going to come out from everything that happened?
Yeah, it's hard to outdo the outlandish facts that we are seeing in the news, but quite frankly, I don't find it that outlandish. First of all, we have or at least almost 150,000 pieces of evidence. Plus, you have a tipster. I think that the FBI is certainly capable of being able to put the tipster's insight plus the evidence that they have at their disposal together in order to see if this is a valid claim to go through. And quite frankly, Jesse, I don't think this is that far-fetched. We have a president here who has been accused of working with Russia or being elected because Russia interfered with our elections. And now the people that he is inciting to go perform acts of violence on his behalf is getting information from the government in order to sell it back to Russia. So although it's almost difficult to believe, I don't think it's that hard to foresee that happening here.
Gilbert, if the sale never took place, but it is true she stole it, and she did have the intention to sell it to a Russian contact, what charges could she face?
Well, we have a very hard time trying to prove if she didn't sell it that this was her intention. The charges can actually be quite a variety of charges. I mean, in terms of being considered to be either an aid to a foreign cell, being a foreign cell herself. We don't know how deep this can go. I agree with Gigi. This is an incredibly ludicrous, actually, scenario that none of us would have imagined mere weeks ago, as much as we've seen. As you saw with the CNN clip, a lot of pictures were being taken of confidential information. People were writing on staff members' notations in the event that it can be proven that she actually did steal this laptop or intended to sell it and was prevented either by law enforcement or that she withdrew prior to actually going through with it. She could be facing some very serious time, some very serious charges, but there would be numerous depending on what the facts bear themselves out to be.
All right, well, we want to talk a little bit more about the riots. We'll take a break. When we come back, we'll get more into it. Stay tuned. That's Officer Eugene Goodman leading that crowd, that group, away from the Senate chambers. There's even talk that he should receive the Congressional Gold Medal for his actions that day. And you know what's interesting, Gigi, we look at this and we look at the good actions of people that day, but we're really focusing on the bad actions. And when we last left off, we were talking about how Riley June Williams, one of the alleged rioters that day, is accused, or at least being investigated, for possibly stealing a laptop from Nancy Pelosi's office and trying to sell it to Russia. We talked a lot about her actions, Gigi, but if there was somebody on the other side, you know, there's one sense to say, hey, maybe she was just going to sell it to her contact and that was it. They didn't even know that was going to happen. But if someone was planning this from Russia and, you know, had planned this and said, hey, Riley, you're going to come there, you're going to steal that laptop, you're going to give it to us, are there any repercussions? And this is obviously an ongoing investigation. We don't know what's really true and what's not. But on the other side, could there be consequences for that Russian contact or for the SVR if they, again, the Russian intelligence service, if they actually maybe orchestrated this plot or were key in trying to get Nancy Pelosi's laptop?
Yes, absolutely. And we've seen other administrations punish this type of behavior with Russia. I believe Obama, just before leaving, or excuse me, transitioning President Trump, he issued very strict sanctions against Russia, which were ultimately lifted by Donald Trump. So there's definitely a possibility that pending an investigation and once we discover what actually played out here, that the new administration under President-elect Biden will enforce strict sanctions against Russia and potentially bring in those who may have committed crimes against the U.S. But then again, we know that Russia doesn't have an extradition treaty with the United States, so it might be pretty hard to bring them over here for trial. But that's not to say that the new administration won't attempt to.
And you know what's interesting, Gilbert, is the fact that, of course, there's video evidence of what people did that day. But a lot of times you're hearing from family members, friends, or in the case of Miss Williams, her ex, who is reaching out to authorities and saying, listen, he or she did this, or he or she was going to do this. And it's the closest people who are actually turning them in are going to be the biggest witnesses, because there seemed to be talk about what was going to happen before January 6th, or maybe even after January 6th. And they become the key witnesses in this, Gilbert.
Well, actually, Jesse, I mean, this entire matter is so incredulous that it shouldn't surprise many of us that even friends and family would have been shocked and appalled and outraged at the mere fact that everybody that talked about breaching the Senate and coming into the Capitol building actually did it and performed it. As we both know, all three of us here, there are many federal cases where state's evidence is turned by a lot of very close witnesses and close family members. But this is so shocking, not just to the nature of the entire country, but anybody that knew any of these people, they might have figured, oh, maybe you're just talking, maybe you're just saying this. But I'm sure that to see it actually happen, that some people might be surprisingly eager to provide accurate information because it's nothing that they might have thought would have actually been carried out.
Yeah, and I think that's a really good point. Yeah, it's hard to believe. All right, we're going to switch gears because there's another big case. We have an update for you. You might have been following this one. It's an update in the Andres Guardado case out of L.A. Now, the first inquest in Los Angeles in more than 30 years has been completed, and it has been determined that the death of this 18-year-old is a homicide. This also, of course, results after a sheriff's deputy opened fire on Guardado back in June, striking him 5 times. Guardado allegedly had a gun on him and he ran away from authorities, but his attorneys, the attorneys representing his family, say that's inaccurate. Let's turn actually to Commander Chris Marks, who talked a little bit more about whether or not Guardado had a weapon on him.
There were 2 Los Angeles County deputy sheriffs involved in this incident who gave chase to Andres Guardado on foot, which ultimately led to the deputy-involved shooting. The deputy who did not fire his weapon has been interviewed by Sheriff's Homicide Bureau. The principal deputy who did in fact fire his weapon and struck Andres Guardado is scheduled to be interviewed by Sheriff's Homicide Bureau investigators, but that has not yet occurred. The cameras seized at the scene pursuant to a search warrant did not contain any video recordings of the event. We are aware of the independent autopsy conducted at the request of the Guardado family. We have not yet been notified by the Los Angeles County Medical Examiner that the official autopsy report has been completed. A security hold of that report was requested by homicide investigators until all interviews have been completed. Homicide investigators requested that security hold in order to prevent any compromise in this investigation. I've also learned that there's some reports, either on social media or in the media, that the gun recovered at the scene was not real or a toy. That is not correct. The gun has been tested. It is, in fact, a real firearm.
Okay, Gigi, explain to us exactly what an inquest is, because it was seemed to be ordered by the coroner's office, why this is a big deal, and what does it mean for this case?
It's an official investigation to determine a cause of death. It's a big deal because an inquest has not been requested in LA in over 30 years. So the fact that there was a judicial order to say, coroner, look into this some more to make sure that we can get an accurate cause of death, right? We know that we had an independent autopsy that previously determined that this was a homicide when Mr. Guardado, the teenager, was shot 5 times in the back. And now it's a big deal because the LA coroner's office has also come to the same conclusion. And we know that police officers are justified in using deadly force if there's imminent threat of death or great bodily harm to themselves or others. But with that said, the facts don't appear to support that because now we know that this kid was murdered when he was shot 5 times in the back. And LA can clear that up by being transparent and showing us the body cam and showing us the evidence that they were justified in that use of force.
Gigi, real quick, why is an inquest rare? Why don't you always, in any kind of these, shootings or controversial shootings, why don't you always just request this?
I believe it's because the coroner's office generally they make their decisions based on the autopsy, so it just goes through the motions. Versus an inquest, it's a judicial determination. Hey, coroner, go back in and investigate this, and it's a judge telling them to go look into this versus the normal routine.
And Gilbert, we believe that the inquest is now being sent over to the sheriff's department, the prosecutors. Based on this, doesn't it mean they have to press charges against the officer or officers involved here?
Well, Jesse, to me, it would seem that they would have pressed charges a long time ago, even before the inquest, at least have an investigation and before the inquest is released. I say this because as provided by Law&Crime, there's the complaint that lists the fact that some of these video cameras, it was said by neighbors and people who were in the neighborhood that they were working, that some of this footage was actually destroyed. We have 5 shots in the back, which to me, you don't need a law degree to understand. 5 shots in the back does not equal self-defense. We've seen far too often police officers looking for a gun, which was either never recovered or eventually maybe recovered, but who knows where it might have come from. So I would agree with you, Jesse, in that they definitely need to go forward with charges pursuant to this medical corroboration of what was already known, sometimes by mere common sense.
And Gilbert, one follow-up question for you as well. Miguel Vega, who apparently is the deputy that allegedly opened fire on this 18-year-old and killed him, it's by all accounts he was going to assert his Fifth Amendment right. Now, the court in this inquest didn't address that issue. If that's the case, if he doesn't really provide any information, is that a good legal strategy, and what does that tell you?
Well, although usually, of course, with any client that I would have, and I'm sure Gigi would agree with me, we prefer that our client not surrender any rights. When someone tells you you have the right to remain silent, they're telling you have a right, why surrender it? Make the prosecution prove their case. In an event like this, I'm sure that even without the testimony of Officer Vega, they can still proceed, as is many cases where people do not provide information regarding what may or may not have happened. There's several questions, again, about the body cam, about how this incident even began, because my understanding is that the victim was an off-duty security guard standing in his driveway when this chase began. So why would he need to try to open fire? And I don't know how the police officers are seeing a gun when he's being shot in the back at the same time.
And Gigi, I'll give you the final word on this. We talked about this inquest being forwarded to different departments. How do you imagine it's going to play out within the next few months?
I'm hoping we see charges against Officer Vega for his seemingly unjustified use of force, a deadly use of force against a kid.
And maybe that's what'll happen. Again, it's weird to talk about an inquest because we really haven't seen it in so long. We don't talk about it a lot in these cases. But maybe this will be a change because of what the coroner's office did in LA, that if God forbid we do have another kind of shooting, maybe that's a new precedent that will be set and maybe more of these requests will happen. But let's see how this ultimately plays out. We're going to take a break, but when we come back, we're going to switch gears and focus on the death of Phil Spector, a major case in America. We'll be right back. And welcome back, everybody. As many of you might have heard, music producer and convicted murderer Phil Spector has died in prison. Now, in 2003, a jury found Spector guilty of second-degree murder for shooting actress Lana Clarkson. His legal team had argued at the time that Clarkson killed herself. One member of that team was his trial attorney, Linda Kenny Bodden. And she, of course, is our very own host and analyst here on the Law&Crime Network. And Linda released a statement. I'd like to put it up on the screen. And here we go. It says, "This morning, I learned of the passing of Philip Spector. As most of you may know, Philip was a musical genius who was a songwriter, musician, and record producer who developed the Wall of Sound. He was also my client. During the time I represented Philip, I was able to get to know both he and some members of his family. He was a loving father to his daughter, Nicole, and my heart goes out to her. My sincere hope is that he is reunited with his son, Philip, in peace." Gigi, I'd like to start with you here regarding Linda's statement, because there are people who look at this and say, okay, Phil Spector is a man, he died. At the other time, he's a convicted murderer. We can't forget that. He lost his appeal. He didn't get a new trial. He was convicted of murdering this woman. Your reaction to Linda's statement?
Linda just proves herself time and time again to be a kind and zealous advocate. It's important to keep in mind that, yes, our clients committed difficult, atrocious crimes and were convicted for those crimes, but they're also human beings and they have families and they are brothers and sisters and fathers and uncles. And it's important to keep that humanization in mind when we are discussing these types of defendants, discussing any type of defendants. And I think that Linda Kenny Bodden's statement was kind and true and heartfelt.
And Gilbert, what's your reaction to just play devil's advocate here? Because, the family, the victim's family, on the other hand, maybe doesn't want to have Phil Spector remembered in this way and believes that his legacy shouldn't be about the music, but should be about the shooting.
And again, as Gigi said, and I have to display my bias, you as well, Jesse, have sat beside Linda and the phenomenal attorney that she is. Her comments do not marginalize the death of Linda Clarkson. That's not what it's meant to do. It's not meant to minimize the role of Spector in this case. This is coming from an attorney that people do have to understand, just as Gigi said. Time and time again, we get to know our clients' families. We get to know them. We get to know everything about their personalities, their histories. And there's many things that people don't know outside of, say, one or two moments in time, because many of these events are a turn of events that happened within a couple of minutes, if that. And a bad decision can take someone down a life-altering path. I think that it just shows her humanity, which we all know about. And again, I hope that the public doesn't take it as her trying to marginalize somebody's death or trivialize it, but merely to acknowledge the relationship that she had at that time. And I believe that she should be allowed, not only as an attorney, but as a person, to voice that upon somebody's passing.
And Gigi, this was a major, major case. I mean, do you remember when these charges came down? Do you remember the trial at all? I mean, this was one of those big cases. I think it was made into a movie. Who was the actress that? Ellen Mirren actually played, I think, Linda Kenny Bodden. So when you think about this, there was a lot of eyes on this. And what did you make of it when the charges were ultimately came down and the trial came to be?
So I'm going to be honest with you. In 2009, I was an aloof college freshman who was not paying attention to the news as often as I should have been. But when I talked to my father, who was a huge Phil Spector fan, when I was researching this topic, he told me, how dominating this trial was, and how everyone who enjoyed his music in the 60s was glued to this. And, even lead singers of, for example, Blondie, they came out and said that Phil Spector had, an affliction towards waving guns at parties while he was drinking. So, when you were watching the trial take place, as my dad said, it was hard not to take those types of accounts that you heard from other superstars and play them out during this trial. So, though I don't personally remember, I know that this trial definitely impacted a lot of advocates at the time.
And Gilbert, it was an interesting trial from a legal point of view, right? The idea that the defense was saying the victim killed herself, shot herself. That's a tricky defense.
But if there's anybody that can pull off a tricky defense, of course, it would be Linda Biden. A lot of times there are things
that is true. That is true.
that and successfully, by the way. There's a lot of times I think that upon investigation, I tell people every time a trial begins, it begins to take on a life of its own. And there's sometimes when any attorney and even sometimes prosecutors might believe that the theme that they thought or started out with to begin has ultimately changed based on testimony or evidence that they learned later on.
And I'm curious, Gilbert, we look at this, it kind of feels a little bit like the Robert Durst case, in the sense you have this high profile individual charged with the murder of a woman, a lot of eyeballs on it. There's an entertainment kind of Hollywood aspect, a high profile. And we know that the Robert Durst trial is scheduled for a few months from now. There is an intense fascination in our culture, in our society with these kinds of cases. And I'm curious why you think that is.
Unfortunately, I think that America in and of itself has a fascination with the criminal justice system in terms of the more quote unquote spectacular parts. Anytime that there's somebody who's famous, and unfortunately, we tend to view famous people or people that have acquired what we consider fame in a different light. Sometimes as if they either can't do any wrong, or sometimes they've been fashioned, their public persona has been fashioned in such a manner that it seems shocking and way out of character for them to do certain things. But the trial has not been started, so we never know what really has or hasn't happened in the Durst case. So we can just call this deja vu.
Well, it did start. It just has to restart. There were parts of it that started. They got in through opening statements, some witnesses. They just are going to now continue it again. That's a whole separate story, maybe for a different day. But we're going to move away from a case that everybody seemed to know about, to one that maybe a lot of people don't know about, but it's really fascinating and actually heartbreaking. There's this story out of Louisiana about these parents of a 16-year-old named Eric Parsa. They have filed a lawsuit alleging that the sheriff's office is responsible for the death of their son. According to his family, Parsa, who was on the autism spectrum and had limited language skills, he had an outburst after a visit to a laser tag center, and they claim that this was due to a sensory overload. When officers arrived, Parsa allegedly hit one of them. Deputies forcefully restrained him, and the parents say that their son suffocated and died as a result. Now, we do have this video from one of the eyewitnesses. It can give you more context about what happened.
Oh.
Okay, Gigi, let me start with you. Talk about the lawsuit. Is there strong grounds for this? There seems to be evidence that if these officers didn't get involved, this young man might still be alive. What do you think of the lawsuit?
That is a good point, right? Because we know that the victim in this case was a young man who had autism and was suffering from a sensory overload from his interactions at the arcade. We know that those sensory overloads don't last forever. They eventually, people with autism eventually calm down once their senses are calmed again, right? So we do know for a fact that without any intervention, this person would still be alive. And I think that this particular case just shows why it is so important that police officers have either better mental health training or are assisted by actual trained mental health professionals when addressing these calls. Here, the police officer treated the victim as if he was the average violent perpetrator, and he used his body weight to try and subdue him. And maybe in another with another type of person, that might have been more effective, or we would have seen a better de-escalation. I don't know about that because we don't have good success with putting all of our body weight on the backs of people for minutes, 10 minutes, 5 minutes, what have you. We don't have good success with that. But you have someone here with autism who required a different standard of care than that was given to him by this police officer. So I think that, there is good standing for this lawsuit, but it is going to take a long time to decide whether the sheriff's office was actually responsible for the death.
Gilbert, I turn it to you in the sense of, okay, let's talk about the deputy's office here and maybe what defense they have. In the sense they're responding to a call, the parents had consented to 911 being called. They come upon this really chaotic scene, and again, this young man is accused of hitting one of the deputies. They put him to the ground for 9 minutes and 6 seconds, long time. But at the same time, according to this lawsuit, they knew, or one of the deputies knew, that this young man was autistic, and they should have had that, kept that into account. At the same time, isn't this what they're trained to do, to subdue a suspect and just try to alleviate the situation from him harming himself or others? So the question is, how much could the defendants be responsible for this?
Well, I think that's why it's appropriate to be brought in civil court at a civil standard. As was said earlier, the training of the police officers, as well as the ability to have medical personnel. When you're talking about 9 minutes, and I don't know how far away the nearest hospital and the nearest ambulance might have been, being able to be in communication with medical personnel would have been incredibly important. I do know a little bit about what I listen to. Obviously, anybody that's seen my physique knows that fighting is not my forte. But when you put your entire body weight on somebody in a wrestling match or in any type of fight, that is the easiest way to try to subdue someone when they can't move, because your whole weight is resting against that person. And when you're talking about 9 minutes, you are talking about a very significant amount of time. I think in terms of civil liability, when you're looking at the fact that police officers are trained to respond to these specific types of situations, whenever there's a person in this condition, they have to be treated accordingly, and not as if they are just attempting to attack somebody to perpetrate some type of criminal action. So I think that there is a good chance, it will depend, of course, on what comes out during discovery, but that the sheriff's office might bear some civil liability here. How much remains to be seen.
That you just led me into my next question, because Gigi, apparently the family is looking for an unspecified amount of compensatory and punitive damages. What could that number be if it goes to a jury and a jury comes back with a verdict? What number could you look at? And number two, let me ask you this. Is it more likely than not that this case will settle? And how much would that settlement look like?
I think this is more likely going to be settled. I don't see this type of case going to trial, only because you have such difficult facts that, even if the police department finds that, the officer did everything he was trained to do, or excuse me, the investigation finds that he did everything he was trained to do, and that he didn't deviate from his training, and that is what any reasonable officer would have done when faced with those circumstances, you still have to go to a jury and explain that one of their own accidentally killed a person with autism, a teenager with autism. So that's you already have a very sympathetic victim for the jurors, and to overcome that is really difficult. Usually these settlements, I would imagine somewhere in the high 100,000s or maybe possibly into the millions. I really couldn't tell you, but I would imagine that this is going to settle for a pretty penny.
Okay. We're going to finish out our show. We're going to take a break, but when we come back, we're going to finish off with the college admission scandal. More specifically, Massimo Juanelli. Could he get out of prison early? We'll be right back. And welcome back, everybody. We want to talk about Massimo Juanelli, the fashion designer, the husband of Lori Loughlin, the man who got caught up in the college admission scandal. Well, he wants to serve the remainder of his prison time at home, in home confinement. He and his wife, as you know, had pled guilty to conspiracy charges, and his attorneys say that their client has spent almost 2 months in solitary confinement due to inmates testing positive for COVID-19. Now, his lawyers say that this is unfair. This is far more extreme than what his 5-month sentence actually called for. Gigi, I'll start with you. Is this a strong argument? I know there's like photos of him recently in prison. He looks really frail, doesn't look good. Spending his time in solitary confinement for what he ultimately pled guilty to. Do his defense attorneys make a strong argument that maybe this is not fair and that really, if he's going to serve his time, but let him serve it at home?
Very strong argument. Solitary is meant to be a punishment, right? You don't just send folks to solitary. And the fact that this person, a nonviolent offender, who pled guilty, was subjected to 2 months of intense isolation with a few 20-minute breaks a week. That is a much harsher sentence than was initially sentenced. He was supposed to spend 5 months and a minimum.
Gigi, I think we lost you there.
Between that fact
Gigi,
and the fact
Gigi,
that
I'm sorry, you cut out for 1 second. You cut out for 1 second. So you were just saying that you don't think it's fair about the way he's being treated for the sentence that he ultimately, was issued, and that ultimately maybe home confinement could be the right area.
Exactly right. He's been in 2 months in isolation. I think that by letting him go on a bracelet and finish his confinement at home, that would be a great way of splitting the baby in this case.
Well, Gilbert, I seem this whole show to be playing devil's advocate with you because there are other people who look at this and say, for anybody else who would have pled guilty or was convicted of what he was facing, and those were serious conspiracy charges, they would have gotten significant prison time. They wouldn't have been able to serve any time at home. Would it be fair for him to spend only a few more months of his time back at home, for him to get home confinement? Is that fair?
Well, again, I have to side with Gigi on this case. We have to look at a few things. The first, we are not dealing with a violent crime. We're not dealing with a violent conviction. So as soon as you're dealing with a nonviolent crime, there are different categories that we believe should be placed when somebody is confined in prison. Secondly, it was agreed upon by the judge that this was supposed to be a minimum security prison that he was going to be spending his time at. And we almost have literal insult to injury where he had COVID, gets isolated. Now he's still isolated because of other people that have COVID. And as we've all seen from the Khalif Browder story, we do not want to go down that road again. I believe that in fairness, the restriction of having an ankle bracelet, of being confined only to a certain area within your home or within a certain distance for the remainder of the sentence, I believe would be fair. And I would argue, if it were somebody else, I would argue the same thing. Would they get the same treatment? That's a different story. But I think you should be able to temper justice with mercy. And in this case, that would be the appropriate action.
Follow up to that, again, yeah, he's been in solitary confinement, not good for anybody's mental well-being. But real quick, we have about a minute. If home confinement is the ultimate decision, what does that look like? You said he would be confined to one area of the house. How does that work?
I meant an area in terms of within a certain yardage of his home. I believe in home confinement, you can move about the house and maybe go out to your front door and, within your yard, but I don't think it's wise to go down the block.
Right.
You're monitored, but you're restricted.
I don't think. Yeah, because then you'd be sent right back to prison, which is not where he wants to go. It's interesting that he's dealing with this, considering he's taken multiple tests, COVID tests, and keeps coming back negative, but they're keeping him isolated because of the other inmates. All right, we'll see. Gilbert, Gigi, pleasure as always to have you both on. And Gilbert, well, thanks for coming back on the Law&Crime Report. Everyone out there, appreciate you taking the time. We will be back every day here at 12 p.m. Eastern. Until next time, be safe. We'll see you then.